When we think about the highest courts in the land, we usually picture these massive, hundreds of pages long verdicts, right? Just heavy philosophical debates about the nature of our liberties and the theoretical boundaries of the state. But today, we're diving into an explainer of source material that takes the exact opposite approach. It is a literal masterclass in judicial efficiency and pragmatism, and it all revolves around a situation any of us could theoretically face: standing before the police and choosing to just keep our mouths shut.
So, that forces us to ask a really tough question. Does refusing to speak to the police inherently cast a shadow of guilt over you? It's that classic dilemma, isn't it? I mean, you absolutely have the right to remain silent, but does actually using that right legally prove you've got something to hide? Human nature kind of assumes that if you're 100% innocent, you're going to shout it from the rooftops to anyone who will listen. But, well, the justice system is supposed to operate way above our basic human assumptions. And this inherent tension, it's exactly what brings us to the core conflict of the court document we're unpacking today.
Let's start our story with the applicant here, David Ashley Price. Back in September 2001, Price found himself convicted by the Southeastern Cape High Court on two very serious counts of fraud. Now, the source text actually doesn't dwell on the nitty-gritty mechanics of the fraud itself, and honestly, that's a crucial detail about how this court operates that we'll loop back to later. What really matters for us right now is that Price felt his trial was fundamentally flawed. He deeply, truly believed his constitutional rights were trampled on during the whole process that ultimately led to his conviction, so he decided to fight it, all the way up the chain.
Now, you know, when you're convicted at a high court in South Africa and you think a legal error happened, you appeal. It's the logical next step. And Price tried exactly that. He appealed the initial conviction, but brick wall. Both the High Court and then the Supreme Court of Appeal totally refused him leave to appeal. He was rapidly running out of runway. So he makes this desperate legal climb, knocking on the absolute final highest door available to him. He seeks special leave to appeal directly from the Constitutional Court of South Africa.
And what exactly was his argument when he knocked on that final door? Well, he leaned on a very specific constitutional protection. Price threw up a crucial constitutional shield, Section 35(1)(a) of the Constitution. This is the section that explicitly guarantees an individual's right to silence when dealing with police authorities. Price's whole argument was that during his initial trial, his decision not to give certain information to the cops was unfairly held against him. He was saying, look, I wasn't being evasive, I wasn't being deceitful, I was simply exercising my fundamental, totally lawful constitutional right.
And man, this perfectly sets up the central courtroom conflict the Constitutional Court had to unravel. On one side, you have the original trial judge, who basically looked at Price's refusal to talk and explicitly found it unacceptable in the circumstances of the case. The judge was essentially drawing an adverse inference from his silence. And pushing right back, you have Price, fiercely arguing that this judicial approach entirely offends his constitutional right to silence. Because think about it. His argument is basically, what good is a right to remain silent if the judge just uses that exact silence as a brick to build the wall of your guilt?
So, this brings us to what we can call the supreme constitutional dilemma. At this stage in the narrative, we have a textbook setup for a massive legal showdown. You would absolutely expect the Constitutional Court, the ultimate authority on these things, to deliver this sprawling, landmark ruling, right? You'd brace yourself for deep dives into legal philosophy, examining the absolute limits of human rights, weighing the rights of the accused against the practical needs of the police. You'd expect this epic document analyzing if and when a trial judge can ever legally consider a suspect's silence.
But, surprise, that is not what happened. Not even close. Judge Yakub, writing for the Constitutional Court, delivered an incredibly brief, highly pragmatic judgment of just 250 words total, literally. Just 250 words to decide a supreme constitutional appeal about a fundamental human right. Instead of taking the bait and writing some massive legal textbook on constitutional theory, Judge Yakub completely bypassed the main philosophical issue. He opted for this razor-sharp, purely practical approach that just cuts right through all the courtroom noise.
Let's break down exactly how he pulled this off. To solve the dilemma without getting completely bogged down in theory, Judge Yakub used a brilliant what-if legal maneuver. Step 1. He explicitly says, okay, let's assume entirely in favor of the applicant that it was absolutely not permissible to draw any adverse inference against him from his silence. Step 2. Following that assumption, let's exclude the fact that he was silent from our consideration altogether. We wipe it from the record. Poof, pretend it never happened. Step 3. Now, with the silence completely erased from the board, let's evaluate the remaining evidence of guilt for those two counts of fraud.
And the result of that incredibly pragmatic three-step test? Well, he delivered this absolutely devastating conclusion. He wrote,
The evidence of the applicant's guilt is so compelling that there is no prospect that the applicant's convictions will be set aside. Boom. Judge Yakub decided that even if they agreed with Price completely about his constitutional right, actually, scratch that, even if the trial judge was totally wrong to consider the silence, it wouldn't change a single thing about the outcome. No purpose would be served by even considering the validity of the constitutional issue, because the baseline evidence for the fraud was just too overwhelming. Special leave to appeal? Instantly refused.
Now you might be wondering, did this hyper-efficient, strictly pragmatic approach cause a huge rift among the other judges? Nope, not at all. This wasn't just a rogue opinion by a single judge wanting to beat the traffic home. An incredible 10 other justices unanimously concurred with Judge Yakub's judgment. And we are talking about absolute heavyweights of South African jurisprudence here. Chaskalson, Longa, Sachs, Kriegler, Madala, the whole shebang. All of them looked at Yakub's 250 words and wholly agreed. Basically, when the evidence of guilt is undeniable, independently of the constitutional complaint, there is simply no need to waste the court's time debating theoretical rights.
As we wrap up this explainer, I want you to really chew on the precedent this sets for how courts operate. Is justice better served by answering grand constitutional questions at every single opportunity, or by recognizing the undeniable reality of compelling evidence? Price tried to use the Constitution as a technical loophole to escape a mountain of facts, but the Constitutional Court flat out refused to play the game. They showed us that the highest law of the land isn't just about abstract theoretical rules, it's about practical truth. So what do you think? Should the court have answered the silence question anyway, just to set a firm precedent for future cases? Or was their 250-word dismissal the perfect, efficient execution of justice? It's a fascinating reality to ponder. Thanks so much for learning with me today.